I would like to congratulate all of you for following the ethical rules and being here for the whole program. As you can see, a lot of people have already bailed. I know that you guys, most of you probably feel like you've been babbled to death, but Eric and I are going to try and make this as exciting as possible if we can do that for a topic such as this. What we're going to do in the beginning here is just kind of talk to you briefly about what we're going to go over, and then we'll kind of get into each section. Feel free to ask us questions if you have any. First place for everybody in the room to start, the rules. If you don't have a book, get one. We refer to them often. You should too. Everybody should. It's something that everybody needs to keep an eye on. The preamble to the rules I thought was kind of a cool thing. It kind of talks about what our responsibilities are. Basically, we hold ourselves up to a higher standard, which also means that if you happen to not be here this morning or leave early, you need to report that too. Just a hint. Okay, highlights of what we're going to do today. We're going to talk about violation overview of the major violations that occurred in 2013. The reason that we're giving you the numbers from 2013 is because the report doesn't come out every year until May of the following year. So we're giving you the most updated information that we have. We're also going to talk about a couple of rule changes that may apply to everybody in the room. How to deal with opposing counsel, how to deal with clients, how to deal with the court, how to deal with our coworkers, and finally, how to handle some tricky situations. Sorry, I'm trying to figure out how to use my little button.
We want to start with a warning. We understand that parts of this may be dry. Go figure. But we are going to try very hard to make this entertaining. In addition, we understand there's a lot to cover. It's very important. I promise to talk very fast, which comes very easily to me. And we are going to end with trying to make it a little bit more interactive, so that everybody's not just looking at their clocks, they're actually paying attention and interacting in the presentation. So, starting with the violation overview, according to the Office of Chief Disciplinary Counsel, I'm going to only call it the OCDC going forward, there were 1,939 complaints of attorney misconduct in 2013. Of those 1,939, 186 cases resulted in some form of discipline. 8 of the complaints resulted in an attorney being disbarred. 25 resulted in suspensions, 4 probations, 9 public reprimands, 104 written admonitions, and a partridge in a pear tree. The number one area for practice, or for investigations, go figure, was domestic. The top 10 violations. So this is going to be kind of like a David Letterman. The top 10 violations in 2013. Number 10, client confidentiality. Number 9, improper advertising. Number 8, unauthorized practice of law, which includes acts by paralegals and assistants. Number 7, conflicts of interest. Number 6, improper withdrawal, which included failure to give proper notice to the client. Number 5, dishonesty, fraud, deceit, misrepresentation by the attorney. Number 4, charging excessive fees. Number 3, essentially trust account management. Number 2 was diligence, and can we all guess number 1? Communication! That was exciting, right?
Okay, we're going to go over now just the top 5. We're going to briefly describe each of the top 5 violations and give you some pointers on how not to be the person that's getting admonished by the OCDC. The 5th rule violation had 94 investigations, Rule 8.4C. It is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, misrepresentation. What does that mean? It could be not filing your taxes. This is actually a big one that a lot of Missouri attorneys get themselves in trouble with, is if they don't file their state taxes. You can be admonished for that. If you commit any act of violence, as we're all supposed to follow the rules of the entire state, not just the rules of professional conduct, breach of trust, or serious interference with the administration of justice. A lot of times you think more of this if you're dealing with some kind of jury tampering or buying witnesses or things like that. Not necessarily what we may get involved in domestic, but here's a little video clip from the runaway jury that is everything you should not do.
30 years in the trenches have taught me this. Everybody has a secret they don't want you to find. Find something on every one of them. What do we got, people?
Ricky Coleman, 36 years of age. Her husband's a Baptist minister. She had an abortion 2 years ago. And the guy holding her hand at the clinic, not the minister.
Yes. Trials are too important to be left up to juries.
The defense has retained Rank and Fitch as their lead jury consultants.
Ladies and gentlemen, let's find 11 more jurors just like her. Who's next?
Nicholas Easter.
Miss Easter, that's the second time you've looked at your watch. Are we keeping you from something?
I think if you knew my situation, you might...
Situation?
We accept this job. Go ahead and take it.
No objections, Your Honor. Enter Mr. Nicholas Easter as a juror.
This whole thing is a disaster.
They give you $16 a day. That's a price cash money, baby. Think about that for a second.
$20 million ought to be enough to secure a jury.
They're using video surveillance, wiretaps, finding out things about jurors, their husbands and their wives don't even know.
This is about you messing with my case and the rules of law. That's what I was hired to do.
Obviously, not good things. Bribery, jury tampering, saying $20 million will get you a verdict. You guys get the point. Let's not do it.
Rule 4-1.5, again, excessive fees. There were 95 investigations in 2013. The rule is that fees must be reasonable, but the question always is, well, what's reasonable? There are 8 factors that guide attorneys in the OCDC in determining the reasonableness of fees. You have the PowerPoint presentations in front of you. There are 8 factors. I won't read them to you because it's all in front of you. So you have all 8 factors available to each of you. I'm going to show you a clip. This is a very realistic portrayal by Matthew McConaughey on how to request client funds.
Hey boss, can you do something about that? Because I can.
Nah, just keep doing what you're doing.
Boss.
Alright, pull over up here.
Counselor?
What can I do for you, big man?
Our boy Harold called from the pen, said you're stalling this case. Do you see some more green?
I don't get paid, I don't work.
We paid you $5,000.
That's long gone, Eddie. It's time to refill the tank.
What? Another $5 grand?
10. Either pay me or go with a public defender.
This happens to me all the time.
You gonna count it?
I just did. Roll, Earl.
So, maybe the fees weren't excessive. $15,000 for a criminal representation. Perhaps it's reasonable. I encourage my friend Matthew here to consult those 8 factors. But also he might want to look at Rule 4-1.115, which deals with trust account management. There were 235 investigations. So obviously, Matthew should have perhaps produced billing to show where the $5,000 went, and get out his hourly fee agreement and his correspondences to client telling them that they needed to replenish their trust account or replenish their retainer, and also make sure that he had an hourly fee agreement that he executed with the client. I encourage everybody to go to the Lawyer Trust Account Handbook, which is available at this website, which is also in your material.
I was just thinking, I wish it was that easy to collect money from a client.
Yeah.
I kind of don't want them swarming my car.
Well, at least get a bodyguard. Okay, moving on to, this is actually the number 2 rule violation, Rule 4-1.3. There were 347 investigations. The rule states that a lawyer has to act with reasonable diligence and promptness in representing a client. We're going to go over a couple of the tips on diligence and kind of how you can make sure that you actually abide by the rule. First, professional discretion regarding how the matter is to be pursued is always supposed to be something that you're in charge of, not the client. Also, make sure that you're not using offensive tactics. It gives you a bad reputation for one, but also it doesn't always get you where you or the client want to be. Treat people with courtesy and respect. And moving on here, control the workloads to ensure competence. If you are a sole practitioner or if you are working in a large firm, there should be some type of a strategy in place so that you know that when you have too many cases, you have too many cases. Each case should be given the same amount of attention, and if you are unable to do that, then something else needs to happen in order for you to be able to diligently represent the clients, whether that be hiring a new associate, law clerks, maybe a paralegal, somebody who can help you out with the work. Avoid procrastination. This is one of the #1 complaints of last year. Over half of the reports for violations on diligence came from people who procrastinated and simply were just not prepared either for trial or a hearing, and the client not only did not get the result that they wanted, but felt like that they were not getting adequate representation. Carry through on all matters that are undertaken for the client. If you have it into a written contract, what you're going to do for them, make sure that if you're doing a limited entry of appearance for something, the client is fully aware that that's the only thing that you're helping them with. If you have kind of veered into another area, for example, you're handling a divorce, but it's over, and now you're handling a quadro, was that something that was originally in the agreement? Or is that something that you're now taking on, or the client had an expectation that you were going to do? As long as you clarify what the relationship is in writing, then you should have no problems being able to handle diligence.
Sean!
Oops. Sorry. This movie is Night Falls on Manhattan. It's ages old. But it proves the point of being prepared and being able to adequately handle your cases. Now hopefully it'll work since I... Okay, here we go. Sorry about that. Okay.
Sean! When we captured Jordan, and we win, he's going to be tried. It's the easiest case this office will ever have. He left one empty gun behind, his prints are on it. I'll bet you whatever you want, ballistics will find bullets in one of those 4 cops that came from that gun. He's the worst dope dealer in Harlem. A murderer of his own people. A monster. As I said, the easiest case this office will ever have. I hope they get him alive. Because I want him put on trial by this office. You know who the prosecutor's going to be? You, Sean. You're going to try. That's right, you, Sean. You're looking at me like I'm crazy.
Morty, apologies to you, Sean. Morty, this is a giant case. Sean has never tried anything like this in size or importance.
Mr. Morgenstern, Mr. Harrison's right. I mean, I'm new at this. A mistake to new in the case.
There's no problem here. My son could win this case, and he's not out of high school. And he's stupid. This case is not complicated.
Well, are you serious?
I always tell when I make a joke. I'm the guy who laughs loudest.
Obviously some issues if he doesn't even know what he's doing and they're trying to put him on a huge murder case. Point being, make sure that you are not the one that is saying, I don't know what the heck I'm doing when you walk into court on that day to represent the client.
As a reminder, the #1 violation is communication. There were 375 investigations. If we refer to Rule 4-1.4, a lawyer shall keep the client reasonably informed about the status of the matter, promptly comply with reasonable requests for information, and consult with the client. Of the 375 investigations, continuing on 4-1.4, a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make reasonably informed decisions. And then we have some tips for how you should do this. First, you should notify the client about significant developments immediately, including settlement offers. You should review important provisions before proceeding to an agreement and explain the strategy to the client, the prospects of success, and the tactics that you're going to employ, including expense that may be involved. Regular communication to clients minimizes clients' requests for additional information. In addition, requests for information should be promptly responded to, and all calls should be promptly returned or acknowledged. I encourage every firm to have a policy in place so that the client has reasonable expectations when they can expect a return call. At our firm, it's all calls, all emails are returned the same day, and the clients know it, and they hold us to it. The only time you would withhold information is if the client would be likely to react imprudently to an immediate communication. So if you're going to deliver bad news, some people require that bad news in person. Next, we have a video clip from Aaron Brockovich, and it's a video of an example of a lawyer who struggles with effectively communicating with his client.
People, listen, please. Please. Now, the point we have to address tonight is getting everyone to agree that going binding arbitration is preferable to a trial that could go on for 10 years before you see any money. Maybe some of us want to wait 10 years. Everyone has to agree or no one has a chance. Those of you about to leave, I'd like you to keep this date in mind, 1978. That's the year of the Love Canal controversy, and those people are still waiting for their money. Think about where you'll be in 15 or 20 years. Huh? Now look, everyone, is this a big decision? Absolutely. But I do not believe, and I wouldn't say this otherwise, I do not believe this is a setup. This is the best shot at getting everyone some money now. You and I both know there are people in this room who can't afford to wait, to take that chance. Are you going to make them wait?
So you got to speak their language. There are some overlooked areas for suspension. One, failure to pay state taxes, Rule 5.245. Failure to pay the annual enrollment fees, Rule 6.01, subsection F, which I fear is about $400, and failure to comply with MCLE requirements. Thank you all for complying with your MCLE requirements. Now on to rule changes. You're welcome.
Okay, these are just a couple of rule changes. They may or may not apply to the majority of the group here. The biggest rule changes that occurred near the end of 2012 that went into effect in July of 2013 was the former Rule 4-115, which was solely about trust account management, has now been divided into 4 separate rules, which are listed at the top, 145 through 122. And it explains everything that you could possibly need to know about your Missouri IOLTA account. And refer back a couple of slides ago when Erica gave you the website moiolta.org. It has a full handbook. You can't go wrong. It's like 40 pages, but it literally walks you through the entire process, especially if you're doing your own thing, and awesome if you are, then make sure that you're doing it right, because this was a huge violation for people misusing trust funds or just having them set up improperly. The second rule change was Rule 5.09. Now allows the OCDC to use subpoenas to obtain information to determine whether to move forward with an investigation. And they can do so on behalf of either a disciplinary hearing panel or committee or other division that is investigating. It could be, the other division could be Missouri Department of Revenue, it could be the Motor Vehicles Division, it could be Social Security. There are a lot of reasons why they may have to get involved for a potential violation of the rules. But it now allows them to use subpoenas in the jurisdiction that they are in, which was not something they allowed before. Rule 6.01 increased our fees, which I'm sure you all knew when you got your information in January. It went up, I think, about $100 per year to now a little over $400 a year. And Rule 6.03 now claims that if lawyers are exempt from paying the enrollment fees every year, then if you go on inactive status, you are the same as the people who don't have to pay enrollment fees. So basically, if you're inactive or you are waived, then you don't have to pay the fee. Inactive status used to make you pay.
So you want to be an ethical attorney. So here's some tips on dealing with opposing counsel. Now, contrary to popular belief, we're lawyers, not liars. Rule 4-4.1 addresses obligations to not tell a lie. So you want the truth, and in the course of representation, representing a client, a lawyer cannot knowingly make a false statement of material fact of, or law to a third person, nor can you fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless the disclosure is prohibited by Rule 4-1.6, which is confidentiality.
Correct.
See, I got these Missouri rules down. Next, I'm going to work on Wisconsin.
So they're the ABA rules, which you follow too.
So, well, what is the truth? First, there's misrepresentation, and a lawyer is required to be truthful when dealing with others on a client's behalf, but generally has no affirmative duty to inform an opposing party on relevant facts. So you cannot misrepresent, but you can withhold pursuant to confidentiality. Well, is all fair in love and divorce? The comment to this rule refers to the statement of fact. So whether a particular statement should be regarded as one of fact can depend on the circumstances. And under generally accepted conventions and negotiations, certain types of statements ordinarily are not taken as statements of material fact. So when we're looking at the facts, one comment suggests that the value you place on assets or settlement negotiations, those are viewed as opinion statements and not held to the statement of material fact. Rule 4-3.14 addresses fairness and a lawyer's obligation to be fair with opposing counsel. Notably, you can't obstruct another party's access to evidence. You can't alter or destroy or conceal a document. And you can't advise your client to do the same. You can't falsify evidence, and you can't allow your client or another witness to testify falsely. In addition, in pretrial procedures, you cannot file frivolous discovery, and you must comply with discovery demands that are sent to you. Rule 4-3.4 also includes that in trial, the attorney cannot allude to any matter that the lawyer does not reasonably believe is relevant or that will not be supported by admissible evidence. And you can't insert your opinion either during the course of the testimony. Finally, you can't try to talk a witness other than your client or a relative or an employee out of testifying. So the big takeaway you have here when dealing with opposing counsel is you got to play by the rules. And the comment, subsection 1 of the comment says, fair competition in the adversary system is secured by prohibitions against destruction or concealment of evidence, improperly influencing witnesses, obstructive tactics in discovery procedure, and the like. Don't hide or alter the ball. You cannot encourage your client to violate the rules, and those rules include complying with discovery. Although it's not very common, sanctions are available if the behavior is egregious. You can file a motion for sanctions with the court if the opposing counsel is so difficult that their conduct warrants the filing of a motion for sanctions. So here are some tips. Play hardball in a kind and reasonable manner. Be civil, always. Don't talk negatively about other attorneys. Word always gets around, especially at the courthouse. Develop a reputation of good things, fairness, truthfulness, and tenacity. We have a clip here from Intolerable Cruelty with Catherine Zeta-Jones and George Clooney. And George Clooney is giving an example of that opposing counsel that he just can't stand.
Don't try to bait me, Miles. Now, if you have a proposal to make, let's hear it.
Well, at this point, my client is still prepared to consider reconciliation.
My client's ruled that out.
My client is prepared to entertain an amicable dissolution of the marriage without prejudice.
That's a fart in a stiff wind.
My client proposes a 30-day cooling-off period.
My client feels sufficiently dispassionate.
My client asks that you not initiate proceedings pending his setting certain affairs in order.
Well, what's so goddamn funny?
Please, let me handle this. All right. So much for the icebreakers. What are you after, Freddie?
My client is prepared to settle for 50% of the marital assets.
Why only 50, Freddie? Why not 100? While we're dreaming, why not 150? Are you familiar with Kirshner?
Kirshner does not apply.
Bring this to trial, we'll see if Kirshner applies.
What's Kirshner?
Please, let me handle this.
Kirshner was in Kentucky.
Kirshner was in Kentucky?
Kirshner was in Kentucky.
All right, Freddie, forget Kirshner. What's your bottom line?
Primary residence, 30% of remaining assets.
What are you, nuts? Have you forgotten Kirshner? Freddie, it's a negotiation.
See you preliminary.
Freddie, we're all friends here. It's a negotiation. Hey, Freddie, fine. We'll eat the pastry.
Arguing with a lawyer. It's a lot like wrestling with a pig. You'll both end up covered in mud, but the pig likes it.
Okay, now we're going to talk about dealing with clients. This is always my opinion only, there are two kinds of clients. Those who did it to themselves, you know who they are, they're the ones who caused the divorce, they're the ones who are the problem, or those who are the victims. Generally, they're the same client also, just in case you were wondering. And either way, the clients are not happy. We're getting our clients at the worst possible time in their lives. They don't want to listen usually in the very beginning, so it's very complicated for us to figure out how do we get through. So here is a clip from the Social Network, and despite his lawyers trying to prepare him for a deposition, this is how a client can get quickly out of control.
Is that a question?
In the 16th email, you raised concerns about the site's functionality. Were you leading them on for 6 weeks?
No.
Then why didn't you raise any of these concerns before?
It's raining.
I'm sorry?
It just started raining.
Mr. Zuckerberg, do I have your full attention?
No.
Do you think I deserve it?
What?
Do you think I deserve your full attention?
I had to swear an oath before we began this deposition, and I don't want to perjure myself, so I have a legal obligation to say no.
Okay, no. You don't think I deserve your attention?
I think if your clients want to sit on my shoulders and call themselves tall, they have a right to give it a try, but there's no requirement that I enjoy sitting here listening to people lie. You have part of my attention. You have the minimum amount. The rest of my attention is back at the offices of Facebook, where my colleagues and I are doing things that no one in this room, including and especially your clients, are intellectually or creatively capable of doing.
I appreciate your honesty.
We've all been there, right? Where you're sitting in a depot and you're just like freaking out because the client will not stop saying things like that. The point is, how do you prepare them? Sometimes you can't. You're dealing with difficult clients. But a couple of things for you to make sure that you're protected. Rule 4-1.1, competence, indicates that a lawyer shall provide competent representation to the client. Basically, what does that mean? Know what you know, and if you don't know it, then find an answer, okay? If you don't have an answer, then ask somebody, research the issue, make sure that you're strategizing either with yourself or another attorney if you have the opportunity to speak to someone else about how you should possibly handle the case. I encourage you to do so. And also, as much as you possibly can, try to prepare the client. This advice is really, in particular, important in family law, since domestic is the #1 area of violations for the rules of procedure. But one of the most important things that I can say is always don't get into an area of practice that you don't know something about. And a lot of areas that could possibly come into play, we'll talk about in a second, that may stem off of a divorce, handling quadros, handling any type of tax issues if you don't know anything about taxes or things like that. So always make sure you're consulting with someone who does know, an accountant or anybody else who can help you in an area that you may not be particularly familiar with. Preparation, as I discussed, is key. Obviously, they probably did prepare him for his deposition and he just chose to kind of do his own thing. Here are the areas where I was kind of talking about. Appeals is a big one. There are a very small group of attorneys in family law who handle appeals. And that's because appeals are very difficult, and if you don't win, then that could be detrimental to your client. On the plus side, you're making law, which is nice. But quadrants is a huge area of concern for a lot of us who do family law because it's a big area that we don't necessarily understand. We could be dealing with a state pension for teachers that isn't divisible at all. We could be dealing with a federal pension that is completely different on how the order is written than a order for just like a Boeing pension or something like that. So make sure that you're consulting with somebody who knows what they're doing so that you don't get in trouble down the road. Just some additional tips. Make sure you know the changes in the law. Obviously, coming to these CLEs, not just this one, but any ones that you go to where you can get yourself updated on any kind of information is beneficial to you. And here are some tips with dealing with the clients. Remember, the first time they come and see you, as fired up as they may be, their story is probably as good as you're going to get it. So that's your opportunity to really hammer them and nail them down on what are the facts and what are the goals, so that when everything hits the fan a few months after that and you realize that they're lying through their teeth, you can kind of refer back to the first meeting and say, but what about this? And make sure that you have a client prepare a list of goals. It's important for everybody to review that list with their clients throughout the process because the goals may change, especially as time goes on throughout a case. Make sure that you're emphasizing, especially in family law cases, that there's a lot of discretion with the courts. One of the biggest things I think all of us have to overcome is explaining to a client why a judge has the ability to do what he does or she does. And discretion is the hardest thing to explain to anybody because it's not cut and dry, it's not black and white. And that's what the client wants. So being able to explain something to a client about how the law works and breaking it down, I know a couple of the other speakers talked about this, taking out the legalese and turning it into common speak, maybe running it by each other even. I mean, we may understand it, but if you have a legal assistant in your office or you have other support staff and you can say, hey, does this make sense? If they tell you no, your client is not going to get it either. So make sure that you're explaining everything throughout the legal process in a way that the client best can understand it so you can protect yourself. Be cautious of the clients, bless you, who say that they want a bulldog attorney, or when you realize you're the third or fourth attorney, something's going on. Most of us will be willing to talk to anybody who takes the case from us and explain kind of where we were with the process and what had happened so that you're kind of prepared for what's going on. I encourage you to do that. I mean, if the attorney won't talk to you, then I guess they won't talk to you, but at least try so that you know what you're getting yourself into. In addition, if a client insists on a course of action that's contrary to what you believe should happen, remember that the rules do state that the client is ultimately the decision maker in their case. They're the ones who kind of guide how things go, but that doesn't always necessarily mean you have to do everything that they want them to do. So make sure that you're just covering yourself and that you're telling them the difference between your advised action and the actions that they want to take so that they know what the repercussions could be if they don't follow what you think is going to happen with a particular judge or jurisdiction. This is really hugely important for a lot of the rules because you'll notice that they all kind of come together, but your office staff has to have some type of policy for how to deal with clients as well. And this will flow into confidentiality in a minute, but they have to know what the process is. If you have a client that's calling belligerent and is being hugely disrespectful, my personal policy is I have a strongly worded conversation with that client that it's unacceptable behavior. You know, in a way that they get that we know you're going through a really tough time and you're frustrated, but you can't treat the staff the way that you're treating them, okay? So just make sure that if you're dealing with difficult people, everybody in the office has an idea of how to handle it. And make sure that you're candid with the client, going back to making sure that they understand what you're saying. And here's a big one. If you think that a client needs some type of counseling, psychiatric care, if their problems have now gone to a level where your attorney and counselor at law is more counselor than anything because they're calling you every day crying about what's happening, it's probably a good idea to start thinking about referral services so that you can get them some help throughout this process. Pursuing a different course. If under Rule 4-1.2, I just indicated that the client is the person who gets to determine whether or not what course of action that is taken, but there are caveats to that. And if you are strongly against something that the client is trying to do and you cannot talk the client into a different course of action, it's very important that you go through the proper process of attempting to withdraw from the case. Because you're also limited under the rules of what you can tell people about why you're getting out of a case. You can't just say, he has this course of action that I don't agree with. You have to be very cautious you're not revealing information. So make sure that you have these conversations with the client over and over again if it is something that you know is not going to be something that you're going to agree with, okay? Also, I wanted to point out two things with regard to withdrawal. If you know that the representation that the client wants you to take will result in a violation of any of the rules of professional conduct or the actual laws of the state of Missouri or the United States, you are obligated to withdraw. Again, you have to be very careful in your motion to withdraw what you say. And you may withdraw if the client continues to try to involve you in services that you think are going to be causing some type of crime or some kind of fraud. And you should be able to kind of tell that by the questions that they're asking, etc. So know that that is an option and a possibility for you. Confidentiality, I think that we all kind of know what confidentiality is. The important thing that I want you guys to remember is the client has to give informed consent before we can release information about their case. So if we're getting ready for a settlement conference or we're getting ready for a pretrial, the client has to be aware of what facts that we're going to be putting forward in the conference with the judge or with the other attorney. Again, they're the ones in charge of their representation, so they're the ones who say, I want you to talk about this information or I want you not to. And we'll get to some exceptions to that right now. There are only 6 exceptions that we have for whether or not you can release information. If you know that the facts are going to, or the client is going to cause death or substantial bodily harm to themselves or someone else, if you're trying to prevent them from committing a crime or fraud, if you're trying to rectify substantial injury to the financial interests, for example, they're going to take money out of the account or liquidate some account that you know they shouldn't be doing. If you are asking the OCDC questions about whether or not you are violating the rules, you can release certain amounts of information to them so they can properly advise you. And if you are involved in a case where your client has sued you for some reason, either they filed a bar complaint or we're doing some kind of a fee dispute, you're allowed to release information, and then as permitted by law. We'll get to that in just a second on what that means.
Something wrong? Is your brother all right? I ain't talking to the FBI today, and that's fine.
Mark, you have to talk with the FBI. If you don't, they could subpoena you.
Fulton is going to be here any minute.
I said no. Now, you're my lawyer, and you have to do what I tell you.
This place is a dump. Say that again.
They are coming down the hall.
Make him go away, please.
All right, stay here, stay outside. Something's up. I don't get it, but I will do it. Just sit down.
He said, you're my lawyer and you have to do it. So as long as she knew that he wasn't going to be committing some kind of crime or committing some kind of fraud, she followed what he was supposed to do. And now we move back on here.
So when we were dealing with the court, here is a clip for my cousin Vinny, who really models, may it please the court. The lighting's not really great, but it's a nice bright red velvet suit.
Mr. Gambino, are you mocking me with that outfit?
Mocking you? No, I'm not mocking you, Judge.
Then explain that outfit.
I wore a suit. You seen it. Now it's covered in mud. This town doesn't have a 1-hour cleaners, so I had to buy a new suit. Except that the only store you could buy a new suit in has got the flu. You get that? The whole store got the flu. So I had to get this in a second-hand store. So it's either wear the leather jacket, which I know you hate, or this. So I wore this ridiculous thing for you.
You on drugs?
Drugs? No. I don't think.
The proper close with that, no, I do not take drugs, Your Honor. Rule 4-3.3 addresses respect and candor to the court, which includes truthfulness and making sure the court is following the proper laws, even when it's not in your favor. The rule also includes producing only truthful evidence and also notifying the court if your client is engaging in criminal conduct that is relevant to the case at hand. This is a continuing duty throughout the case, and this applies to any interaction with the court. This puts us in a tricky situation. What about when your client plans to lie on the stand? Rule 4-3.3, you cannot allow the court to be misled by false statements of the law or fact or evidence that the lawyer knows to be false. You can't let your client lie under oath. You have a couple options. You could take a recess to discuss it with the client. If the client continues, you can do an oral motion to withdraw, and the court knows while you're withdrawing. And if you're not allowed, you must notify the court of the testimony problem.
Be careful with that, because you really have to only give them a minimal amount of information. You can't say, Judge, my client's gonna lie. So just be careful with handling those kind of situations. They will come up.
Now, what if while you, after you've submitted your briefs to the court, and you're planning to argue your motion, what if a new case comes down that completely squashes your position? If it is overruling your position, you have to notify the court. Rule 4-3.3. What if you later on discover that you produced false evidence or testimony during the trial? The lawyer has to take reasonable remedial measures, which includes discussing with the client and advising the client of the lawyer's duty of candor to the court, and advise the client that you have to withdraw or correct the false evidence or testimony. And note that this obligation ends after the review appeal period has ended. You do have an obligation to rectify false evidence, and that evidence ends at the conclusion of the proceedings. And again, that ends after the appeal period runs out. Ex parte issues. So if you obtain an ex parte order, for example, a restraining order, or how did Heather, somebody call out, how am I supposed to phrase that here?
An OOP or a TRO.
Yes, an OOP or TRO. In addition to the rule, there is a comment regarding ex parte proceedings with the court, where an attorney, as an attorney, you have a duty to provide sufficient information so the court makes a well-reasoned decision. So if you're pursuing an ex parte order, you do have to produce evidence that even if it's not in your favor. The golden rule when dealing with the court is know the law and be prepared. How do you improve your knowledge of the law? Well, read the state statutes, including not just the divorce cases, but also civil procedure, discovery, evidence, depositions. If you were performing a modification, review the prior judgments and research both sides to any issue so that you can also anticipate opposing counsel's arguments to prepare your defense. Do more than just the boilerplate discovery request, because you need to know more details about the case, and that goes further into Scott and Kelly's presentation earlier this morning. See how we go full circle? On preparing an effective cross-examination. Interview all witnesses prior to testimony. Get the good and the bad so you know what will be said at trial. Take the high road when possible, and limit your reactions in the court, which don't help your case. And we all know, our favorites. The heavy sighs when the court says something. The head shakes. The open mouth stares. The chuckles. And the same rule applies for your clients. I prep all of my clients before we have any testimony, and I explain to them, I don't want to see this. As they're feverishly writing down, she's lying! And it's written so big that the court can see exactly what he's handing to me. So prepping your clients ahead of time for testimony to make sure that they know that they need to keep a straight face. And advise the client that their reaction can win or lose a case. So this is a clip from A Time to Kill, and it's the judge's perspective on how the case should proceed.
Counselors, you may have noticed a sudden tourism boom in our town. Our courthouse has become the subject of a lot of national gawking and squawking. Well, here's what I don't want. I don't want to be seeing on TV how that racist judge Omar Noose conspired with the DA to hand a black man a white jury. We were here, all of us are here, for one reason: to serve justice in this case. Let me make one thing real clear. I won't tolerate any monkey business, you understand?
I know a couple judges in St. Louis County that say stuff like that before we get to trial. Okay, so bottom line is, we know how to deal with the courts. We just need to make sure our clients do. Dealing with coworkers is also an important issue that can get people in trouble with the rules as well. Rule 4-5.2 is the rules that relate to having subordinate lawyers in your firm. If you are a solo, bear with me. If you are not, then this is important. If work is provided by a subordinate attorney at your direction and it's in violation of the rules, both of you can be brought up on violations. However, the subordinate attorney, as long as they were acting at the discretion and direction of you, will likely not have any violations against them, but you could still be held liable for directing them to do certain things. In addition to that, if they say, you know, she told me to do it, that's the big one, right? She told me so. Still important thing for everybody in the room, especially if you are an associate attorney and you have managing attorneys above you, is that if they tell you to do something, but you have the knowledge to be able to make the decision as well. For example, if there's a conflict of interest that's something that's easy for you to decipher in the law, then you could at that point be responsible also. So it's very important to have conversations when you have other attorneys working on your files about what your expectations are so that everybody is following the rules properly. We're all partners in crime. The important thing that we need to remember is that if something can only be answered one way and it's very clear-cut, everybody's in trouble, equally responsible. So you need to make sure that everybody's protected.
And who are you?
Rudy Baylor. I work for J. Lyman Stone.
Oh, you work for J. Lyman.
Staunch supporter of the tobacco lobby.
Where is Mr. Stone?
Honestly, Your Honor, I don't know. He was supposed to meet me here, and I don't know where he is.
Well, why doesn't that surprise me? So what do you want? You want a continuance?
No, Your Honor. I'm prepared to argue this motion.
Are you a lawyer?
Well, I just passed the bar, and these are my clients. Mr. Stone filed this on my behalf until I pass the bar.
Well, you got a hell of a lot of nerve walking into my courtroom without a license. Now get the hell out of here, get no license, and then you come back.
Obviously, you're not sending somebody into court who doesn't have a license, hopefully, but it kind of goes to show that you have to be responsible for your work product as well. If you have support staff, you're also responsible for anything that non-lawyer assistants do on your cases. It's very important that they understand that these are the guidelines. So if they're sending out work product that you haven't reviewed, and there are mistakes or there is something that is in there the client didn't want to have disclosed, that comes back on you. It does not come back on the support staff. The important thing to remember here is that you have to have conversations with everyone in your office about what the expectations are. This goes for not only disclosure of information that may be in a pleading, but also confidentiality. I know frequently people will call the office collection agencies just trying to get information on clients, saying, hey, we have a mutual client in common. We have nothing in common because we don't have anything from the client that specifically states, I can talk to this person. You can't even disclose that the person is a client. So it's very important to have internal policies so that everybody in your staff and everybody who works in your office understands that these kind of violations could be on you and that everybody could then be in trouble. Have internal policies. It's super important for everybody to do that. Lawyers always employ assistants. Obviously, some people have independent contractors as well. Make sure if you're going to have experts or you're going to have private investigators or other people working on the case with you, they all understand the same thing. We're all bound by the same rules because you're the one who's in charge of the case. So they have to abide by confidentiality. And that's the biggest one where people get in trouble, when it's other people who are actually doing the wrong because they haven't explained it to them. Okay, here's where it says internal policies. This is comment 2 to Rule 4-5.3. If you don't have a written policy for how cases will be handled by subordinate attorneys or by support staff, it's hugely important that you do so, because in that case only, if you have an internal policy, you're still responsible for the work product or for the disclosure, but you have now minimized what could possibly be an actual suspension of your license to possibly just a written admonition that you need to just be more clear with people.
Those are my files. Yeah, we had them couriered over. And listen, good work. They're a great start. We're just going to have to spend a little time filling in the holes in your research.
Excuse me, Teresa, is it? There are no holes in my research.
No offense. There's just some things we need that you probably didn't know to ask.
Don't talk to me like I'm an idiot, okay? I may not have a law degree, but I've spent 18 months on this case, and I know more about these plaintiffs than you ever will.
Aaron, you don't even have phone numbers for some of them.
Whose number do you need?
Everyone's. This is a lawsuit. We need to be able to contact the plaintiffs.
I said, whose number do you need?
You don't know 600 plaintiffs' numbers by heart. Annabelle Daniels.
Annabelle Daniels, 714-454-9346. 10 years old, 11 in May, lived on the Plume since birth. Wanted to be a synchronized swimmer, so she spent every minute she could in the PG&E pool. She had a tumor in her brainstem detected last November. An operation on Thanksgiving shrunk it with radiation after that. Her parents are Ted and Rita. Ted's got Crohn's disease. Rita has chronic headaches and nausea and underwent a hysterectomy last fall. Ted grew up in Hinckley. His brother Robbie and his wife May and their 5 children, Robbie Jr., Martha, Ed, Rose, and Peter, also lived on the Plume. Their number is 454-9554. You want their diseases?
So obviously he had a conversation with her about what his expectations were of her. The other attorneys just weren't so sure.
A quick comment about social networking. The OCDC has guidelines, but these are of course evolving as technology evolves. We did include an article for you, I believe it's on the thumb drive, that was recently released with an opinion on social networking. So the first question is, well, maybe it's not clear in the rules what you can or cannot do, but should you? Tweeting. I believe there was a local prosecutor who tweeted a high-profile criminal case, and the OCDC found that there was a violation based on diligence and candor to the tribunal. So don't tweet your cases. In addition, friend requests through Facebook. Should you friend the judge? Should you friend your clients? Should you friend opposing counsel? You definitely shouldn't friend opposing party. When you're looking at these rules, we want to make sure we're not showing collusion with others, and that could be an issue. So we encourage you to review the article. The article is pretty thorough. I think it's what, 3 pages? 3 pages. You cannot convey impression of influence was the theme that the article definitely had. But it was a good read. So safe social networking, review only public portions of a party or witness's Facebook page. Do not post any references to your clients or cases on your personal page. That's going to reveal confidentiality, or client's confidential information. Do not make derogatory remarks about the judiciary on your personal page. And most importantly, do not friend opposing party under false pretenses, which is, what people sometimes will try to do. Joan Smith wants to friend you, and then now I have all of your confidential information. Well, you just communicated with a represented party. So in summary, as we wrap up, but we're not done yet, we're just going to get to the interactive portion, which is exciting. You cannot control the actions of opposing counsel, the court, or your client. Provide good, documented advice, make arguments, and be a strong advocate. Most importantly, be prepared. So, we're going to kind of let loose. It's 4:08. We've got some time, but correct me if I'm wrong. We only have like 33 minutes left in the presentation because we have to go for an hour and 40 minutes. Matt Allen, are we good? He's not in the room, so I'm hearing it's good. I thought this would be a fun thing to do. So we're doing this interactive part of the presentation, and I said, oh, well, what if you interact? That means you get to go home early. And I was like, hey, this is exciting. And Matt shot that down because it turns out that that's not ethical, which is funny that I'm doing this presentation. So
She's had a little bit of caffeine today.
And I feel great.
All right, here's going to be what we're going to do is I'm going to pop up what the question is. Erica's going to walk around to all of the eager people to stick their hands up. and we're going to talk about what the situation is, and then we're going to give you what the correct answer is. So the first one, husband wants custody of the children and was arrested for DUI with the kids in the car 6 months ago. OC and OP do not know about the arrest.
Opposing counsel, opposing party.
Right, sorry. Do you have a duty to disclose the alcohol violations?
So we are looking for a volunteer.
Or two.
Or two or three. This will be fun, exciting. You can stand up, stretch your legs. Oh, we have a volunteer.
Yay!
I have no idea how I'm going to get you. I'm going to reach. All right.
State your name.
Karen Lewis. I think you definitely have an obligation if there's a discovery request about it. I'm not so sure if there's not a discovery request about it.
I like that she made, can everybody hear what she said? Okay, so I like that she said if there was a discovery request that there was an obligation. How many think of you, raise your hands, how many of you think that you have an obligation to disclose this if you're in the middle of a custody case? None of you, really?
One, two, three.
Okay, those of you who raised your hand that you think you have an obligation, tell us why.
What she said, I was in line with the part about what she said about if there are discovery requests, which in light of what you've taught us earlier today, there would be, because you would do that as soon as possible.
Thank you for listening earlier.
But let's assume there isn't a discovery request. Do you have an obligation? I should not have worn heels.
I think you do. It would not feel good to do it, but I think that ethically you do. And if you are a parent, you know that you would want the parent, I mean, even though it's a custody case, parents are out, they need to know information like that if their kids are in danger, even if it is your client. And it's the right thing to do. And plus, it is discoverable. So if you don't, it could be even worse once they find out it actually happened. Because how many kids are going to say, oh, guess what? We got a ticket today. We got pulled over. They're going to tell their parents. So you might as well fess up and soften the blow.
So that's an interesting point that you bring up, that it's the right thing to do. The client says no. What about Rule 4-1.6?
Which is confidentiality.
But even though it's client confidentiality, it doesn't fall within the realm of that because you were arrested for a DUI. Now, even though the case is pending, you might not get convicted, et cetera, you still have that obligation. I don't think it's protected.
All right, well, let me give my 2 cents, but I'm from Wisconsin, so I think it's only worth 1 cent.
And also, I don't think I would have this.
Exactly. So, we have client confidentiality, and we have what's the right thing to do. The most logical thing to do in this situation is to advise the client, to talk to the client and say, well, here's the thing, it's discoverable. So, client confidentiality, I'm not going to say anything unless there's a discovery demand. But if we don't say anything, and then all of a sudden down the road you don't reveal this, and then bam, there's a discovery demand and they find out through other vehicles, or you're on the stand and it turns out they already have the information because they got the police report because they knew about it because the kid already told them, it could be damaging for their case. So it's more a situation where you need to advise your client. The question with Rule 4-1.6 is this revelation, is this information, is it likely to, if the client had a DUI, is death or substantial bodily harm possible? Well, no. If you know that the client is actively drinking with the kids in the car, maybe you have a duty there because it can result in substantial bodily harm. But if this happened 6 months ago, the client is regretful, not going to do it again. You can't, without the client telling you that you can do it, you can't reveal that information. Even though it feels wrong, that's your duty to advise the client, hey, it's going to come out sooner or later. This is my advice to you, but ultimately, if you don't want me to say anything, I can't.
The other thing on this is kind of a sticky issue, and so obviously we have the rules of confidentiality that say that you can't, and then there are only certain exceptions that say that you can. And of course we don't meet the exceptions in the rules of confidentiality, but here's where you have to look at the rules in totality. Are there other rules that would obligate you? Are there state laws that would obligate you to report this information? So keep that in mind. Some of the other rules we went over earlier, you're not allowed to assist the client with dishonesty, fraud, deceit, or misrepresentation. One of the definitions of misrepresentation was omission. So then you have to determine, would this be a relevant fact in your case? Is this something that would fall under that definition? And if you omit it, then are you putting yourself in trouble for possibly violating the rules by not disclosing it? Bottom line, call OCDC and make sure, because it's a judgment call, because there are so many different rules that are involved.
That's going to be a theme after all of ours. It's going to be like, hey, call OCDC.
Oh, are we going to sing it? We're singing and dancing. Awesome.
I'm going to make it interesting, right?
We might have everybody stand.
Nobody's
and sing and
sleeping
dance.
today.
All right, the next question we have continues on custody. Oh, I'm sorry.
Quick question. Okay, I guess we're assuming under that scenario that there was either a conviction or a plea on that, because if there wasn't, or if there was some extenuating circumstances, I think that there would be an obligation on us as counsel to find out what that is and make that determination.
If there was a conviction that was public record, or you knew that they had actively committed a crime, you do have an obligation under the rules to report it as a fact to the court. Here's where things get sticky again. You have to be very careful what you reveal, because you can't reveal a lot of the information if there hasn't been a conviction yet, because you could actually be responsible for leading them to that. If there is no conviction on the record, then it's a judgment call for you on whether or not you're going to proceed with saying anything about it, because you then could be opening the door when the client said no.
Next, the wife wants primary custody of 2 kids. Husband wants you, as their attorney, to demand custody, and clarifying, your husband's attorney, wants you to demand custody and threatens to reveal 1, that wife had failed suicide attempts 3 years ago. 2, wife told husband she disliked the eldest child because he reminded her of the father. And 3, that during the marriage, wife had an affair that she doesn't want anybody to know about. So, are there any ethical issues with this scenario?
I'm coming over here.
Oh, you guys totally. Tell us your name. I'm gonna get you next.
My name is Gay. Hi. First of all, number 1, wife had failed suicide attempt 3 years ago. Too bad, bud. If you didn't do anything about it 3 years ago, don't bring it up now. Number 2, wife told husband she disliked the oldest child because he reminded her of father. He said, she said. You don't have any proof to that. Number 3, during the marriage, wife had an affair that she doesn't want anybody to know about. Big deal. If you didn't bring it up then, don't bring it up now.
All right. Does anybody else have a different opinion?
Who thinks it's a violation of the rules if you don't reveal the information? By show of hands. Very few. Okay.
So, to clarify, how many of you believe that if you went with client's plan and you revealed all this information, how many of you believe that it would be an ethical violation to go with client's plan? Raise your hand. So it's all kosher, it's good.
We have one comment. Go ahead, sir.
I was just going to say, as far as I can tell, this is information you have from your client. Your client wants to reveal the information. There is not, I'm not aware of any rule that would prohibit you from revealing that information.
Now let's say, for example, you just found it reprehensible. Well, maybe family law just isn't your cup of tea. But if you find that you cannot go with client strategy, your first step is to make sure it's very clear to the client that although it's not an ethical violation to go this route, maybe you think it's too bad, I'm not doing this. And then it's up to the client to choose whether or not they want you to continue representation. Also, as an attorney, you do have a right to withdraw. You may withdraw if you find a course of action to be reprehensible.
You also have to know your judge, because if you bring some of that crap in front of certain judges, they will shut you down.
Absolutely. So there's a difference, I think, and she brought up a good point. Well, if you bring up some of this stuff to the judges aren't going to, they're not going to let you talk about this. There's a difference, though, however, between what you can do ethically and what you should do. The bottom line, it's going to come down to advising your client. Say, if you want me to bring this up, I can bring this up. I would. If there was suicide attempts, if the husband, if the wife was telling the child, or maybe she didn't tell the child, but this information, if the client finds that it's relevant, the client can present the information. Perhaps they're presenting it to a guardian ad litem, or perhaps they're presenting it to the court, but you're advising the client ahead of time, hey, this is probably not going to go over well, or I don't advise you to proceed down this route. If you find it reprehensible, you can withdraw, but otherwise, I mean, this isn't unethical on its face. We all agree? Show of hands who all agrees with me. I like it.
The rules agree too, actually. Rule 4-1.3 states that you have to pursue the matter on behalf of the client, the way the client wants it to be done. And Rule 4-1.2 states that the lawyer has to abide by the client's decisions, despite the fact that the attorney may have issues that they feel the tactic is offensive. However, keep in mind what we talked about earlier, you do have an obligation under the candor to the tribunal and fairness to other parties to not have completely offensive tactics all the time. But sometimes you're going to need to. What about the kids?
Well, that's a good point, but at the same time, we're not calling the kids into court to say these things. Yeah, I agree. It definitely would affect the kids if it...
I think that the client is the client. I mean,
so you're talking about attorney strategy. So there's a very big difference between what you should do and what you can do. So as an attorney, your job is to advise your client, and absolutely, you would say, well, if we bring up a big issue about she told the husband that she dislikes the eldest child, well, what if that gets back to the child? That would be horrible, right? So you're advising your client, but bottom line, if the client says, no, I want all of this to come out, it's not unethical for you to proceed and present that information. But you as an attorney would probably analyze it and say, you know what, I'm not comfortable with this. And if that's your position, I'm not comfortable with this, and client saying, no, I want you to do it, then your choice is to withdraw.
the bottom line is that you're not breaking any of the ethical rules by not presenting the information. Go ahead.
Let's give the mic.
Sorry. I'm kind of concerned about the second one because there is a duty to reveal information if someone is at risk. I mean, to follow up on the point that the gentleman back there made, it could be that she hates this child and she could cause harm to the child because she just doesn't like him. I mean, maybe her father did something to her when she was younger. She could be raped, and so this child could be in danger, you know?
I'm sorry to cut you off. That is a good point, that the child could be in danger, but we're representing the husband who wants to give the information out. So ethically, you have to present the information the client wants to have out, so all this information would come out, and the court would likely then appoint a guardian in all likelihood, around here anyway. But the bottom line is really, are you breaking the ethical rules? Which you are not. You're actually obligated, unless you withdraw, to follow what the client wants you to do. So the kids would be protected at that point anyway. Did you have another question over here?
And just remember, we're not saying whether you should do this or whether you should present it. We're asking, is this ethical?
Yeah, I'm John Burkby, and I agree that it's you don't have to reveal it. However, your scenario, as it appears, you have not stated whether or not husband or husband's attorney has ever even bothered to investigate the truthfulness. What facts are supporting these allegations? And I think that might, go a long way. But just to sit there and say you're going to act on an assertion, I think is ridiculous.
Well, a lot of people probably would agree with John here, but the bottom line is that you aren't acting unethically. If you're revealing the information, it's all about what you believe the client has represented to you. When you're representing something to the court, most of the time you haven't had time to do discovery or to verify every fact that the client has told you. You're basing your strategy on the facts the client has given you at the time. So if they're giving you these facts, are you in all likelihood somewhere down the road going to do some discovery so you can verify? Yes. But you're not violating any of the rules if you present this information. Here's where the catch is. If you find out later he's lying and you've revealed this information to opposing counsel or you've revealed this information to the court, now you're violating the rules if you don't fix it. Then you're under an obligation to tell the client, I know there was a mistake, I know that we now have the truth, And you have an absolute affirmative duty then to notify everybody that there's an incorrect issue that has occurred. And if the client at that point says, no, you're not going to reveal it, you have to withdraw from the case. Delicately, you can't tell the court why you're withdrawing, but you have to get out of the case at that point because now you've attempted to rectify a misrepresentation to the court and the client is not allowing you to do so. Okay? We're getting close on time here, so we're going to kind of move on to the next one. And we do not have the answers to all of these in the handout, but if anybody would like that, just let us know at the end.
So custody for property. Husband tells you he really doesn't want custody, but he wants to use threats as bargaining chips for a more favorable financial outcome. We're going to go to another one because it's along the same lines, where it's behavior that you would find reprehensible, but the client's motives, albeit reprehensible, it's not unethical for the client to say, well, I'm going to use this threat as a bargaining chip on custody and placement in order to get a more favorable outcome for the finances. So we're going to go to the next one. I want a bulldog. I want a bulldog attorney. And I hate it when clients say this because I'm like, have you had a bulldog? They are the most slobbery, snorty, adorable things. Like, that's what you want me to be? I can be that.
Terrifying.
I'm that way all the time. So the client tells you to be hostile, to be belligerent in dealing with opposing counsel, opposing party in the court. I want you to tell her this. I want you to tell him this. I want you to say this to the court, and I want you to tell the court, bleep, 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 bleep. Can you do it? How many of you
or do you have to do it?
How many of you think you have to do it? Raise your hands. That's good.
Yay, awesome.
Save your license there. How many of you think it's unethical if you are to do it? Raise your hands. How many of you think that, no, it's okay, you could do it if you wanted to? All right.
Groups 1 and groups 3 are correct.
Yeah.
The bottom line is, it doesn't make you look very good as an attorney if you're the one who's constantly throwing around threats or being hostile and belligerent towards opposing party or opposing counsel or frankly the court, but you're not violating any ethical obligations by doing so. However, again, where you have to look at the rules altogether, if you're fairness to the court, candor to the tribunal, they do specifically state that you do not have to be disrespectful, especially if the client asks you to. So if you respectfully tell the client, I can't do that, or I won't do that, you're not violating any of the rules by saying, sorry bud, you're on your own on this one. Probably is going to have a little bit of a glitch in the client relationship, but that's a good time to think about withdrawal again.
Let's go next to communication with opposing counsel. Next one. You're having a discussion by phone or in writing with opposing counsel about a case and you state, off the record, have you violated any rules? Well, it'll depend. Are you using it for strategy? Off the record, my client doesn't want me to tell you this. Wait, my client's sitting right there. That's one, right? Then you're fine. But let's say you're about to reveal confidential information. Off the record, my client is crazy. The guy was just in my office. I'm pretty sure he's off his meds. Things are not going well. Just to tell you. Bad idea, right? So, if you're violating client confidentiality, how many of you believe that this is a violation of client confidentiality, assuming, and raise your hands, is it unethical? Do we even need to call the OCDC about that? Well, you might want to. They're probably,
Half the room thinks we need to call, I guess. Hey, don't call. It's unethical. Anything that you say that's off the record, unless your client is literally what Erica said, sitting right next to you and knows that you're revealing the information to the other side, you are violating more than one rule. You're violating even more than the rules of confidentiality. You're violating the rule 4-1.2 that says, hey, the client's the one who makes the decision. If the client says to you, I don't ever want to settle this case, and you say off the record, we're going to settle this case. Not only have you gone against what your client has asked, but you could also be, during that conversation, revealing information the client does not want anybody else to know. So off the record, don't do it. It's a bad idea. In writing, by phone, in person, I'm sure Many people may have done this in the past. Don't do it anymore. This is a huge issue right now in front of the OCDC for clients who are complaining that during undisclosed settlement negotiations with the other side, information is being released that they did not authorize. Huge issue. Any questions on any of that?
We only have 10 more minutes, so we're gonna go skip to the...
We should dance.
Yeah.
Just for 10 minutes. No, I'm kidding. Go ahead.
Let's go.
I just wanted to see if she was still catching up with me here.
Absconding threats. So the client calls and says he cannot take this divorce litigation anymore. He's on his way to pick up the kids from school and leave the country, never to be seen again. How many of you believe that there is something that you must do to inform opposing counsel or the court of what the client's going to do? Please raise your hands very high if you think that you need to. You guys, like, what is very high? That is not very high.
It's like all they've got left.
That is like...
It's all they have left.
All right, so we have one guy over here who thinks that you have to do something right now.
Only one?
Only one person. Oh, way in the back.
Oh, now we're looking alive. Now that's only because we've been threatened dancing again. All right, here's the thing. Do you have to report it? Rules of confidentiality. Is there death or substantial bodily harm that is going to occur? No, but there's a caveat that says that if you know that the client has committed a crime or is going to commit a crime, you have an absolute obligation to report it. Now, again, we have to go back to how much can you report? It has to be delicate. It has to be very thought out, but quickly, obviously, if he's planning on leaving the country, but you have a duty if you know they're committing a crime or fraud to report it.
So we're going to talk to you about a little later about ways that you contact the OCDC's ethics hotline. So you can send a letter, and the response time is what, 2 weeks?
It could be a little longer than that. The last one was like 4 or 5.
This is not a situation where you send a letter to OCDC asking them, what do I do?
If you call them, they'll do it pretty quickly.
You need to call them immediately because you're weighing obligations here. You're dealing with client confidentiality. You're dealing with crimes that are in the process of being committed, and you are potentially dealing with the safety of the children depending on the mental state of your client. Yes, sir?
Unless there's already an order in place, is the client committing a crime by doing this?
If they're leaving the country and they have not stated to mom, hey, I'm going on vacation, or I've gotten passports for the kids, or nobody knows he's leaving town until he says I'm going to pick them up, absolutely, you have an obligation. Yeah, never to be seen again, it kind of is a clue there. If he's planning on taking off, you have an obligation to say something.
But what is the crime?
Well, if he's planning on leaving the country, parental kidnapping would probably be the first thing, I guess, that came to my mind.
There's a statute for interference with parental rights, and also there are statutory provisions that most states have that indicate, well, if you're going to take the children out indefinitely out of the state, then you need to notify the other side. There's a procedure that needs to be followed. Also, oftentimes in family law cases, there's a custody and placement arrangement right away, and so this case was already pending. I mean, we're dealing with this like hypothetical that we just like wrote up. So I can give you some further details about this imaginary person that I created, but there's likely an order as well.
Yeah, I can give you a heads up. I know of a case, because I was involved in it, where the United States Attorney for the Eastern District of Missouri subpoenaed the OCDC files of the lawyer who attempted to get help there. Now, my understanding is they backed off of it, and the court did not compel OCDC to turn it over. But it's possible that if you make a communication with OCDC, it could be used against you in a criminal matter. I'm talking about a felony on the attorney's part, so be very careful.
So my suggestion is always to contact OCDC and then have a detailed note from what the conversation detailed with OCDC, because remember, you're protected in being able to find out whether or not you have an ethical obligation, and you should record what OCDC told you. Wisconsin just started this very awesome thing. It's called email with our ethics hotline. It is fabulous because they respond immediately and I have the response in writing and I can just save it to the client's folder. You guys have the letter option, but the letter option obviously takes a really long time. So I would definitely make sure that you are documenting exactly what you learned in that call, because you're right, you could be aiding a client in commission of a crime, for example, if something bad were to happen beyond just absconding with the child. There are issues. So this is one where we both, Cher and I are both advising, call the hotline immediately. There's not a clear answer here.
And remember too, though, with the rules of confidentiality, there's an exception to the rules if you know that the client is going to commit a crime. And I know that we all have clients who are just kind of like fly off the seat of their pants for 10 minutes and they're mad and I'm gonna go kill her, I'm gonna go grab my kids, I'm gonna leave the country, and then the next second they're like, bipolar, back to calm.
Did I leave you that voicemail?
Yeah, I didn't mean to say that. So it's going to kind of be your judgment also whether you believe the client. But if you really think that something's going to happen and you don't do anything about it, then you are definitely setting yourself up for not just a violation of the rules, but also for probably involvement with criminal litigation.
Now here's one that's a little bit more clear. Your client calls and says he cannot take this divorce litigation anymore and says he wants to end it all. Now, let's say in this that it's very clear that wants to end it all doesn't mean he wants to engage in a settlement. Let's say that he actually is intending to commit suicide. Now, if that is a situation, how many of you believe that you have an ethical obligation to act immediately? Raise your hands. Nice and tall. Come on, get a nice good stretch in. Yeah, because the answer is yes, you do. There, the rules 4-1.6 subsection B, subsection 1, recognizes the overriding value of life and physical integrity and permits disclosure that's reasonably necessary to prevent reasonably certain death or substantial bodily harm to another individual, including your client.
Yeah, you have to make a call. If you know for sure that the client is suicidal or you feel like they've kind of gone off the grid and they're not talking sense, and you at this point you probably have had enough conversations with them to know you have a duty.
Next, we're going to skip around here. We're going to go to, are you allowed to advise your client to delete postings or shut down their Facebook accounts? How many of you say, yes, you're allowed to do that? Raise your hand nice and tall. Stretch, stretch, stretch.
Who's in? Who says yes? I say who's in. Basketball started, I think, like 5 minutes ago.
Okay. The answer is actually no. You're not allowed to do it. If you check out that Facebook article that we provided to you, they specifically address in that article that you're not allowed to do it because it would be destruction of evidence. Now that's different. That's a different situation than if you say to the client, stop posting on your Facebook account about the other side. Do not post anymore. That's different than if you're telling them to destroy evidence that was already created.
Yeah, that's exactly true. So you can tell them it would be nice if you stop saying my wife is bleep bleep, or here's a good one, posting photos of you and your girlfriend and your kids, while you're still friends with your wife or whatever. But if you tell them to either alter, because you can edit actually posts, or you tell them to delete posts, you are in violation of Rule 4-3.4, which prohibits an attorney from destroying or concealing any document that has potential evidentiary value. So it's very important to know that you cannot tell them that they can delete anything. That includes emails or text messages also. You've had that exhibit before where you ask them for their text messages and there's like these huge gaps for like days. And you're like, something doesn't seem right because they've deleted the ones where they called her the bleep bleep. Oh yeah.
Why would it be evidence, since there's still all the background servers, just because the profile doesn't have it on there anymore, you can subpoena the record from Facebook, and wouldn't that be the evidence?
I agree with you, and that was an argument that I made, is because just because you delete it doesn't mean it's not there anymore. But the article is on point and is very clear. And so we saw that as controlling.
Yeah, it was written by OCDC also, and while you could obtain the information from Facebook, how many of you have been successful with that? Subpoenaing Facebook? 0. So you can ask the other side to give you the Facebook postings, but if they've altered them or edited them, there's no way for us to find out what the actual information is. And I think that subpoenaing Facebook is a good idea, but the bottom line here is you can't advise them to do it. So if the client says, can I delete this post, or you look on there and you go, what are you doing? You cannot say you need to get rid of all of that. That's the important factor.
What about changing the privacy settings on a Facebook account?
That is not a violation because you have not done anything to alter the evidence. If you are destroying or altering evidence, that's where you could be in violation of a rule. Yes, ma'am.
What about when they just suspend the account? That doesn't alter or anything, change it?
That is true. They can suspend the account. However, if the other side asks for information, then they have to reactivate the account so that you can produce the information in discovery. Otherwise, you are helping them conceal evidence. Yes, ma'am.
Well, what about the Facebook stalking where they say, well, one of my friends said that they saw her with the new boyfriend and her kids in the picture, but they're obviously no longer friends because they're going through a divorce.
Are you saying, okay, the question was what about the friends stalking somebody else's Facebook? Are you asking if we can use that?
Oh yeah, I use that all the time. You know, when somebody else is producing evidence that they received and I didn't, so it would be unethical if I were to pose as Roberta, and Roberta is wanting to be friends with Jane, opposing party. I can't do that because I am having a misrepresentation, 1, and 2, I'm communicating with a represented party. I also cannot advise anybody from my office to do that. But if client's sister, who still gets along with wife, secretly doesn't like her, but still gets along with her, and is Facebook friends with her, and she's pulling data, absolutely, I use that all the time.
You have to use sister though as to get it in evident, you know, through the rules of evidence, because the client obviously can't confirm that that was the information.
Would this make a difference before or after a case is filed?
It doesn't make a difference either way. If at any point a client asks if they can delete, or you see something that you think that they should delete, you absolutely before or after a case cannot advise them. However, your obligation ends, we talked about this earlier, your obligation ends when the case ends, which doesn't necessarily mean when you get a judgment, but when the appeal period expires, then your obligation ends to, you know, this goes for if you find out after the fact they've altered something or there was something damning on their page that should have been revealed that wasn't, you're in the clear.
And notice here we're talking about, are you allowed to advise your clients to do that? That's very different than if your client did it unilaterally. If your client unilaterally shut down their Facebook account because they went online and they saw on suggestions was to not post on, to check in on your social media sites, and the client sees that and says, oh wow, I've done some really bad things, and your client does it themselves, you don't have any ethical violation there because you didn't advise the client to do anything. Now that may be some issues down the road if the information is not available via discovery. Your client might have concealed evidence that was otherwise discoverable, but in this situation, it's a question of, can you advise the client as a rule, when they come in for a consultation, can you say to clients, hey, shut down your Facebook account immediately, I want you to go and delete every single post that you've ever done. You can't advise them to that, but you can always provide the clients with appropriate strategies for social media use during a case going forward.
We had a question over here.
But can you take the mic over because they can't hear on the other side?
Did we or no? Okay, I'm crazy. Yes, ma'am.
What if they're not your client yet?
That was what Spencer was asking. What if they're not your client yet? It doesn't matter. If they come in, whatever they do on their own time has nothing to do with you. If they ask you for advice on whether or not they can delete posts or they can delete any of this information, that's where your obligation comes in.
Well, what about when, like, for instance, they know,
You give her the mic, give her the mic.
Like for instance, I know sometimes lawyers will just put general information out on their websites or whatever, or little flyers and stuff like that.
If you were advising on your website, you mean? Hold on. I'll get to you in just a second. Okay, if you have, the question was if you have information on your website or you're sending out like a newsletter or something like that, can you advise people that they need to shut down their accounts or delete things? No, you're then creating some type of a obligation because you're giving them advice, whether you're directly giving it to them or not. You absolutely cannot do that in any instance, because if it comes up down the road that it needs to be evidence, then you're in trouble. Yes, sir?
But again, you could advise them that you shouldn't have them. Don't have Facebook accounts and don't make inappropriate comments about the other person on Facebook. You see the difference?
What about, as you said before, no future postings on Facebook? Shut that down. I'm not going to advise you on what to do regarding past.
Okay. Go ahead. Okay. You can't tell them to shut it down. You can tell them to stop using it. Yeah, if they don't post anything from the time that you become their lawyer on, that's not a violation. The issue is if there was anything that was posted, let me tell you something, we all have it. We'll have it in hand. I've got the Facebook post where he said such and such and we go back 2 days later and it's gone. That's where we have a problem. If they don't post anything, we don't have an issue because they're no longer doing what we told them that they shouldn't be doing anyway. But if the big issue is they cannot shut it down. We cannot say you have to completely deactivate the account, especially if the other side already knows that it was there. We have to make sure that throughout the process, as long as they are a client, we have to make sure that we're preserving evidence for the court if that should come up. You actually have a duty to tell them that they have to be able to preserve evidence. You cannot tell them that it looks bad. You have to give them the information to let them know that you have to protect yourself. So you have to make sure that they know that they have to preserve that information. Now, if you advise them and they go and delete it anyway, you haven't advised them to do that. You've advised them to do the opposite. So that's where communication and CYA is good for you, because now you've told them what you ethically had to do and they went against your wishes anyway.
And I highly encourage, again, everybody should read that article. It's a good article. 3 pages, worth the read. All right, how about we do one last one? Friday. All right, so you receive a settlement offer from opposing counsel. When must you send it to your client? How many of you think you must send it the exact same day? Raise your hand. How many of you know what reasonable time means?
It's like the reasonable person in law school. Does anybody still know what that is?
Best practice, send it the same day with an explanation to client, follow up with client. That's probably the best practice, is when you get a settlement offer from opposing counsel, because you don't want, in terms of best practice, you don't want your client hearing it from the other side. Well, my attorney sent it to you last week and you haven't sent it, you haven't read it yet. And the client goes, well, what are you doing? Why are you holding this information? So best practice is to make sure you get the information to the client. Now sometimes that requires giving it to the client, saying to the client, hey, you need to come in so we can talk about this. Or perhaps it means that you need to send a comprehensive letter to the client and follow up with a telephone call. But there are some exceptions on when you wouldn't want to send a settlement offer. Let's say it is really absurd. Like, okay, like along the lines of what we saw in Tolerable Cruelty, where it's just kind of a ridiculous, okay, they just threw this out here and you know your client is going to overreact. There's an exception where you do not need to send it out right away. Instead, you would tell the client that you want to schedule a time for the client to come in, and then you talk about it then.
There are a couple of points I'd just like to add to that. First of all, reasonable is definitely up for interpretation. As you guys all know, throughout all of the law, anytime they say what's reasonable, no one really knows, even now. But as long as it's done according to OCDC within at least a 5 to 7 day period, if you go past that, then now you've kind of gotten to the point where you're failing to communicate with the client. A couple of other things is if the client, even if the client specifically says, I will not accept any offer, or I'm giving you, like we kind of hear through the grapevine what the offer is going to be, and they say go ahead and reject it, you still have an obligation to send it to them, even if they say that you can reject it. So keep that in mind too. It's not something that you can just hold on to, even if they have given you permission to say that they don't want to accept.
All right, we are going to stay. Anybody have any questions? Everybody else is looking at you and saying, don't you dare ask any questions. we're going to stick around. Cher and I are going to stick around. So if you have any questions, please feel free to come up and ask us your question.
Also, at the end of your presentation, it'll give you the number for OCDC, and also it'll give you the information for how to do formal or informal opinions, just so you have it. Thank you guys. Have a good weekend.